Shortly after the Killer Bees, attorneys Beddoe and Bradle appeared in the evidentiary hearing for Aidan Carney, Brian Walsh also appeared before a new judge, also discussing Rule 17 and Rule 14 motions. I hit the live button and did a raw reaction to that court hearing in the hopes that we'd get an update on the federal investigation and the Trooper Michael Proctor status, both of which were forthcoming. So first things first, what's the status of the current federal investigation? Is it still active? Here's what the Commonwealth said about that.
So, Your Honor, it's my understanding that the federal government has never said that they were investigating officers. That's never been a public statement by the U.S. Attorney's Office in this matter. They have released information to the Karen Reed prosecutors that was subject to a federal protective order signed by a judge that is impounded that I can't see. I have also not seen the materials that were turned over to the Karen Reed prosecution team. So I don't know what's in those materials either. I can tell you that I watched a large portion of the Karen Reed trial, and from what I could see, 2 witnesses identified that they had testified in a federal grand jury in that case, when they were testifying in the state Karen Reed trial. It's further my understanding that the federal government acknowledged that they were investigating the death of John O'Keefe, not the district attorney's office and not the state police. It's also my understanding that the U.S. Attorney's Office has not said that this investigation is done.
This is pretty much a reiteration of the Morrissey letters, which essentially denied that the police were being investigated, but Morrissey admitted that he thought he was being investigated due to Rachel Rawlins or something to do with a previous employee. Nonetheless, we have official confirmation that Levy has not said he has closed the investigation yet.
I can say, Your Honor, I have no knowledge of anyone receiving a target warrant. As far as being a state trooper, the district attorney's office, Canton Police Department, any civilian witnesses, I have received no knowledge of anyone receiving a target warrant.
So Morrissey never got a target warrant, but somehow thought that he was the target of the investigation. Guilty conscience, maybe?
And I would suggest that this is premature. That I have filed a TUI request with the U.S. Attorney's Office for the Walsh materials. I told counsel today I think I should file a TUI request for the Karen Reed materials.
Interesting, right? Levy is also investigating the Walsh case, as well as the Karen Reed case. And what do they have in common? The same police and the same DA's office, who thinks he's being investigated.
And I was willing to work with counsel to make it a joint request. I can understand if they want to do their own. But that would be my suggestion, because I would suggest under ALEA, we haven't gotten to the point of the need for the court to become involved and order discovery to be turned over. Particularly discovery that if it was turned over, the people who have seen it would be a violation of a federal non-disclosure. So I'm not prepared to have someone from my office be charged with contempt. I would prefer that we go down the road of trying to work with the U.S. Attorney's Office and see what those results are, report back to the court, and let the court know.
Well, there's a novel idea that nobody ever thought of before. Cooperating with the DOJ. Dun dun dun!
And one last point. I don't think we can say that the U.S. Attorney's Office and the state police work together on this investigation in the matter of John O'Keefe. It looks like it has been completely 2 different agencies doing 2 different investigations. I don't see any, there has been no sharing of information until there was discovery turned over to the Karen Reed trial.
No shit, Dick Tracy. I'm guessing Massachusetts never got the memo. You know, the one back in the turn of the century that formalised cooperation between the FBI and state and local law enforcement.
Well, Your Honor, it's not the case law isn't just about specifically whether or not they worked on this case together, but if there is cooperation in general between the 2 agencies, which clearly there is.
Yeah, nah, clearly there isn't. Somebody should send Brian Walsh's attorneys the Morrissey letters. Anyway, moving on to the Proctor topic. What did we learn from their motion for Proctor's phone?
So, Your Honor, I can tell you that not only did we retain Attorney Stack, and he's received the download of the phone, I am also going through the phone through all of the emails and all of the text messages and anything that could be a statement to try and find Brady material, but I'm also focusing in on Rule 14 statements, and I feel it's my duty under Graham and McFarland to go through this myself and find anything that could be potential bias, but also statements, and I'm doing that. I've focused in on all
I'm happy to hear that, because you'll find that I try to be as transparent as I can to both sides.
Yay! Transparency! Can we trade Arnie Bev for this, Judge?
And when I read this, I don't know Attorney Sachs, and I don't know the computer person either, but this is interesting. The Commonwealth gets to delegate its responsibility to review the materials. The defense isn't objecting to it, but I have never seen special ADAs, special prosecutors assigned to a case, but I've never seen a third party that's responsible for that. And my initial response, honestly, was, I don't think they can do that. I don't think they can delegate that responsibility to an attorney.
Oh my God, I love her. Makes you wonder how she would have handled the prosecutorial misconduct motions filed by Team Reid versus how Arnie Bev handled it.
It sounds like you've got belt and suspenders. You're doing it yourself, and it's a backstop or a double check.
Yes, Your Honor.
For the consultant attorney.
That's the purpose of Attorney Stack. It's not to outsource it, but to double check what the Commonwealth has done.
Okay.
And he's doing it independently.
All right. That's always good to have another set of eyes, I suppose.
Yes, Your
All right. Anything else that you want to talk about with regard to this beyond what's in the papers?
Not beyond what's in the papers, Your Honor. We pointed out that there's sensitive material in there about ongoing investigations. Turn over the phone wholesale would be problematic and could jeopardize ongoing investigations, and as a result, that's one of the key issues of why we can't turn over the phone wholesale.
Alright, so there's your two updates. It seems like Levy is unwilling to say whether or not he has closed the investigation, which, as the judge did point out, the FBI rarely ever do. Just as the FBI never tell people who they're wiretapping, like, duh. And it looks like Proctor's still on the hook. Once disclosure is complete and his phone records are handed over to defence, he's officially a witness in the Brian Walsh trial. Which side calls him to the stand is an entirely different story. However, only Proctor can testify to Proctor's messages. I'm a hazard a guess it won't be the prosecution that calls him to the stand, since that wasn't exactly a successful decision in the Karen Reid case. However, at this stage, anything that DA Meatball decides to do is not going to be a surprise to me. As Attorney Betterow points out, he's tone deaf, so who knows? We'll be keeping an eye on the Brian Walsh case to see if there's any more disclosures made along the way that might be relevant to the Karen Reid case, so stay tuned.